Good to go?
Where's the volume?
Okay, guys, we're good to go?
Up here. What's that? The volume. Oh, yeah. We should be able to hear it.
Okay, buenas,
No,
everyone.
but, oh, if you're gonna unmute. No,
This
the-
meeting is called
what
to
is
order.
this
We're reconvening
showing?
from our special board meeting that was scheduled Friday, July 31st, 2026. Today is August 7th.
You moved it?
It's 2:42 PM.
Hit that. Why not?
Do we need to do a roll call? Okay, Director, roll call,
Chairman Ronald Equavea,
present.
Vice Chairman Ronald Laguarnia,
Estegea,
Secretary Treasurer Anita Arlino,
Here.
Commissioner Angela Camacho,
Present.
Commissioner Maria Cruz.
Here.
Commissioner Luisa Westing is excused from today's meeting. With 5 members present, you have a quorum, Mr. Chairman.
Just Masi, Director. Okay, we're reconvening.
Turn on the volume, please. I can't.
Can't hear me?
No.
Oh, yeah.
Turn on the volume, please.
The talk box. Okay. Okay, so Director, where are we at with the meeting? It's, we were supposed to get some information.
From our legal
Legal
counsel.
counsel.
Yes, yes, sir. He was supposed to work with Ms. Calvo regarding the Second Amendment.
Okay. So, legal counsel?
Mr. Chairman, members, I think probably the best way to start this off is to ask Ms. Calvo to report on her conversations with Duenas Camacho
Okay.
and how that whole process is going and the timeline for that.
Okay. Buenas, Ms. Calvo?
Hi, good
Yeah.
afternoon.
Okay,
Can you
you're
hear
welcome.
me?
Yes, we can.
Okay. Yeah, so as we discussed at the last meeting, I was going to confirm with DCA the validity of its last proposal to complete the work that was required by GIPA. So I did speak with them, and they confirmed that they would be able to complete the updated drawings and ensure the compliance as GIPA requested with the updated rules and regulations. They'd be able to do that within 3 months. And then I also confirmed with GIPA that as after we receive the updated drawings and plans from DCA, how long it would take them to review those plans and drawings and give us the clearance on our building permit application. So they informed me that they are required to do that under the governing, I think it's the soils and rules and regulations. They're required to do that within 30 days. Thereafter, that would be our final, I'm sorry, there's an echo. After the clearance from GIPA, we would take the building permit application to DPW for their review, their final review, and remit the last installment of the permit, building permit application fee, which is about $20,000. They've indicated, or their engineers have indicated that would take about 30 days as well. So all in all, a maximum period of 5 months that we would need for the to secure the last clearance and get the building permit in place.
So Duenas and Associates is saying 3 months?
Yes, maximum 3 months to complete that work.
Okay, and GEPA was 1 month?
30 days. Yes.
Did I miss any other one? What was the other one?
No, DPW, that's the final for the building permit issuance, 30 days as well. Upon receipt of the building permit application with all the required clearances.
Did I hear that Duenas is 3 to 5 months or
3 months. 3 months, yes.
Okay, thank you.
You're welcome.
1 second, we have a little bit of a technical difficulty here. Commissioner Lino, did you get the information? Where was it? Oh, yeah. Ms. Calvo confirmed that from Duenas Associates, they confirmed that they'll be able to complete in 3 months. GEPA, Environmental Protection Agency, that's 30 days, and DPW 30 days. So, yeah, that's looking at 5 months.
For the, thank you.
Okay,
Mr. Chairman, I have one more.
okay, legal counsel?
Ms. Calvo, assuming that that timeline holds, when would you expect construction to commence following the receipt of the building permit?
I'd say to mobilize, I think, which matches the original time period in the Second Amendment. That would be an additional 30 days.
Okay?
So we can hopefully expect groundbreaking in 6 months.
Yes. And
Okay,
so,
I'm
sorry.
sorry, go ahead.
So I did, I know at the last meeting we spoke about the Third Amendment. So I did receive a draft from AG Miller today. I have been tied up for most of the day. I haven't had any meaningful time to review it. But I did notice first, it was drafted as a Second Amendment. So that's one thing, is we have to revise it to reflect that there's already been a Second Amendment. So this would be the Third Amendment. But I will review that and I can discuss any changes with him next week. But I did receive the draft today. And I'll review that.
Oh, I see. Okay, so you didn't get to review it just yet, just the fact that there's a typo on the,
Right, and I mean, the other provisions
it
as
should have
well,
been Third Amendment.
right. And then I'm sure there may be some other revisions, so I can get those to AG Miller next week.
Okay, can we open up the board for questioning?
Well, Mr. Chairman, let me make one comment on the draft amendment, the third draft amendment, just so
Very good.
everybody understands, at least where this text starts the conversation. It does provide, the text of the amendment as I've currently drafted, so we would fill in all these various dates, and it would assume that construction would commence 6 months from now. But the amendment as drafted does say, if there's a typhoon or an earthquake or a labor strike or the government goes broke or any of these things, these force majeure
Yeah,
issues, that our tenant could come back to the board and say, I know what the time frame was, but there's this issue, and we want more time. The other thing the draft says, as it currently exists, is that assuming they hit the timeline exactly as we've talked about it this afternoon, they actually wouldn't be in breach of the deal until the beginning of month 7. So they're supposed to start, if the timeline held perfectly, construction's going to start in month 6. But really, the way this is drafted is if the construction starts at any point in month 6, then everything's good. They don't have to start exactly on the first day of the 6th month in order to be in compliance with the agreement.
okay, sounds good.
if it's beyond their control.
But anything that's like acts of God or something like that.
It's an honor before.
Well, what it says, the way it's currently drafted, given the timeline we've talked about today, it would say that construction shall commence on the first day of the sixth month, not later than the first day of the sixth month. But it also says that we can't declare them in default until the seventh month, actually, first day of the seventh month. So they could actually start at any point in the sixth month and it would be okay.
Okay. Questions, board members?
Do they have to go?
Okay.
Commissioner,
Commissioner Lino?
they have to come up, take for example, that's beyond their control, like what you described, even if typhoon, earthquake or what, would they have to come back? Excuse me again, and allot themselves Fourth Amendment if,
Yes, they would, if there were typhoon,
yeah,
to use
whatever.
that example.
Yeah.
And so they're not gonna hit the sixth month, or there's a war and so you can't get construction supplies onto Guam. Yes, they would have to come back to the commission and say, I know we told you what the schedule was in August, but for this reason, which is totally beyond our control, we're not gonna be able to hit that schedule. Here's our new schedule, and you all would have the opportunity to say, well, we understand that reason, or
It has to stop and then have to come back for a Fourth Amendment. After
if you were inclined to give them a Fourth Amendment, that would be up to you. You're not required to give them a Fourth Amendment, even if there's a typhoon.
Now, I got a question. Let's just say that there was just some delays on outside of the acts of God stuff, like typhoons or something. Let's say it was GEPA or DPW or Winnie's and Associates, let's say, was a few weeks off or even longer than what is written here. What happens then? I mean, it's beyond them.
Well, I mean, they can always come back and ask for your grace and for some more time.
Okay.
But there's nothing in this agreement that would require the commission to entertain a Fourth Amendment just because DCA, for example,
Yeah, not ours.
was taking too long.
Right.
That's not ours.
I'm good with it. If anybody has any other questions?
Are we going to address
Director.
are we gonna address Commissioner Cruz's concern and as well as Commissioner Westing about them paying, the commission and, good faith?
No, that was already addressed. Right? That was or are you talking about the 5%? Or are you talking about the?
Let's go straight to Wesley's email, because she brought up some things that she would like to see happen here. And one was the clock starts ticking when Guam Ancestral approves this third amendment. So when this, we are agreeing, right, on a date to start the third amendment?
As drafted, the clock would start ticking when all the Ancestral Land Commission signatures are on the document.
That's what, yeah. So that's what one of,
That's your email?
Because-
Westing?
We need to move faster than we have in the past on collecting signatures.
The issue is notary public, unfortunately.
And then the other point she made was to tighten or close any language that would or can be interpreted as being required automatic. And forcing.
Camacho?
Please unmute. I'm sorry.
Commissioner Camacho, I'm just reading off of Commissioner Wesson's email. The other point is, to tighten or close any language that would or can be interpreted as being required, in parentheses, automatic, for forcing Guam Ancestral Lands to comply with any future requests from the tenant.
As drafted, what this third amendment essentially says is Northern Markets gets 30 days on any of these timelines. If they miss them, we can't do anything bad to them. We can't default them or anything like that until 31 days after they miss a deadline. So whatever the deadline is as drafted, and you feel free to change this if you're not happy with it, but as drafted, there's what's called a cure period of 30 days. And so long as they get back on track within 30 days, it's automatic. Don't have to ask anybody any permission. But as long as they're back on track within 30 days, then everybody's still good with one another.
Commissioner
The
Reno?
6 months you're talking about is the, for example, the clock starts ticking after all signatures are in place.
Yes.
And then, let's say it's next week, and let's say it's on the 15th, for example. So that's the start, and the ending is on the 15th also of the 6th month we're
And
talking
then
about.
a 30-day.
And then the 30 days period, so that would extend it up to 07, right?
In theory, yes.
That's what she was asking, right?
And her last point was, how could we at some point, she says, at our last meeting, it was mentioned about including a provision requiring tenant to remit a substantial monetary pay down of the outstanding rent as a condition of any extension of the terms, whether delays or need for extension be foreseen or unforeseen, whether under control of tenant or beyond the control of the tenant. Please consider including this condition. I don't believe we have anything.
No, as drafted, it simply says you're gonna hit these milestones. Construction's gonna start within 6 months. And as long as construction has actually started by the first day of the 7th month, everything is good. And unless there's a typhoon, there's no provision in here that contemplates a 4th extension. So if your tenant desired a 4th extension, they'd have to come back, make a brand new request, and you all would have to consider that brand new. And you can make whatever requests of them you would like to.
And no payment whatsoever as per Chairman, Commissioner Cruz, the 50,000 the last time. No payment.
This document has, Northern Markets is not gonna pay you anything for this third amendment to keep going for 6 more months.
No. What I'm saying is, okay, the 50,000, let's say the Commissioner Cruz, what she's talking about, 58,000, also that will be minus from their arrears. I think so. Is
Right.
that right, Commissioner Cruz?
But that's not in this amendment.
No, but that, it's all in,
If
it's
you,
related.
if there was a request for a fourth amendment,
No,
we start brand new, everybody asks for everything and nothing, and you work that out for your, whatever you see fit.
Can you remind me again,
It's Commissioner Camacho,
What
please
does
speak
rent
louder
payment
to
kick
the
in?
mic. That,
When does rent payment kick in?
Tony, Ariola, may you answer that? Tony or Johnny from Gita?
Mr. Chairman,
Okay.
I
Vice
think-
Chair?
Commissioner Cruz mentioned the audio with with the commissioners. Poor audio. Get in here. We can't hear what she's saying.
Oh,
Commissioner Camacho.
sorry, Commissioner Cruz, you said something?
Yes, Commissioner, Camacho. I cannot really hear her.
Can you hear me now? Can you hear me? No.
No, very vague, very little to none. Everyone is clear. Attorney Miller, Kathy, and at times Commissioner Orlino at times is low. Ms. Calvo is good.
So to answer the question about when does rent start, rent starts when the center
starts,
opens and they get their first
Tenant.
rent paying tenants in the space. And there's two types of rent. There's the monthly base rent,
the monthly base.
and then I don't know the number
Additional.
off the top of my head. And then separately, there's what's called participation rent, and we have to go through an accounting calculation about how much money, how much profit is actually being generated. And then the Second Amendment has language in it about how you split the profits.
So we're looking at
Is that what's,
a stretch time.
is that what's inside the contract, or is it?
Yeah,
Yeah, on the Second Amendment.
the Second
On the
Amendment.
Second Amendment.
That's when the rent would start kicking
The
in.
rent
is-
was, yes,
I
yes,
mean,
sir.
They're
upon their
monthly.
first paying tenant?
As soon as they receive payment from
The
Tenant?
from their tenants, as soon as they receive payment from their tenants, then we will start receiving payment from Northern Market.
They're monthly.
Yes.
Rate. How about
And participation rate.
the arrears? When does that start?
It's all in there in the,
in there?
it's all in there. We already discussed that.
I know, but the monthly is different from the arrears. Are they gonna pay, lump sum as a whole for those arrears?
I don't anticipate they would pay the arrearage off as a lump sum.
Well, we are looking at that.
It was discussed, yeah. So I'm sure, Ms. Camacho has a good idea of how that was working into the.
No, I wasn't on the board at the time.
No, the recent ones that, when they came in and you were here, when, Ms. Calvo, you wanna just go ahead and, touch on that just a little bit?
Yes, well, under the Second Amendment, there was a 3-year construction period during which the base rent would be deferred. And then thereafter, as Attorney Miller mentioned, once the project is complete and there's an occupancy permit, then the base rent payments resume. I'll have to regarding the arrears, I know there was,
So my recollection, and this is why you need an accountant, is the, just to pick a month. On the first day of January, they're gonna pay you January's base rent, and you're gonna record that as January's rent.
Right, yeah.
Separately, we will have this accounting reconciliation of the participation rent. And when the commission gets a check for participation rent, the standard accounting practice is you would first apply that rent towards the arrearage. And so you would pay, as the participation rent was coming in, you're gonna keep reducing the arrearage down to 0. And so once the arrearage was at 0, so just to make up another example, let's say 6 months later, you happen to have no arrearage. And so in July, you get a base rent check and a participation rent check, and there's no arrearage. So you're gonna post both the base rent and the participation rent to July's income.
Correct.
So you don't have income going forward until you've paid off all the past due rent. But that's just standard accounting methodology for how do you account for payments where you have past dues.
So we will not be seeing any rent from this project for maybe another 4 years, 3 years and 7 months, hopefully.
If it takes them the full 3 years to construct it, yes.
Let's see, Gil.
Any further questions?
No, I have no further question.
So, Mr. Chairman, if somebody were to make a motion, the motion that I would like to see be made is, number one, to accept the 3 month, 1 month, 1 month, 1 month
Yeah.
milestone calendar as being acceptable to the commission. And that Ms. Calvo and I can work out a third document, a third amendment to the lease, which we probably have to bring back to the whole commission so that you all see all the words, all the dates in it, but we can do that in a special meeting. So we can keep this train moving forward.
Is there any budge on any, we're renegotiating? Can we not see any rent payment prior to, we're renegotiating this? So we have to wait 3 years for construction?
These were the previous board's prior agreements prior. This is what we worked out. We even had special sessions. I mean, special.
And
work
you're
sessions
still
on it.
okay with this?
Well, we considered the the whole conditions that were presented to the board. We had various people involved. We had our land agent Joey was involved. And then we had,
Gita also.
and Gita was in it, and we all end up coming to an agreement to get the project going.
But to agree with it going forward, that's up to you guys.
Well, we're talking about how we got that agreement. Gita was involved. They had work sessions about it.
And
Okay,
so
but
we won't
here,
see any
but,
payment until.
but here we are. That happened before I, was reconfirmed. I don't know how long. It's probably been another year since I've been here. And we're renegotiating. I'm just wondering if you understand what that means.
Yeah, the board, Gita even advised us that, we had all sorts of, I believe the director was, at the time, was involved in that meeting. We went through we had long discussions on the positives and the negatives. And the board ended up, voting for that and agreeing to it. One of the main things was the fact that if we terminated and they were willing to walk away, but if we terminate it, we have to start with a new company again and have them go to the same permitting process. The same thing, and all over the last few weeks in the news, we were there. One of the big political topics was the permitting process, and we've dealt with that for years. There's definitely a problem with streamlining the permitting process, especially at Shippo and some of these other. It took Carlos over a year just for one agency, if not 2 years on that one agency. So we all took that into account. The director at the time, Gita, our legal counsel, and then we ended up saying, this is the most beneficial decision we could make at the time. Yeah. Right there.
I just want to bring to everybody's attention, the board's attention, that if we proceed with this amendment today,
The third.
the third amendment, if we proceed with this amendment and no good faith effort is given by Northern Market, we're not going to see anything until 2030. The year 2030 is when we will be able to see anything come from Northern Market, because right now the commencement, if we're going to look at the dates that Ms. Calvo gave us, the 3 months for Dueñas will bring us to November. The 1 month for EPA will bring us to December. And then DPW, a month or two at DPW, that will bring us way beyond January into February. And then 3-year construction will bring us to 2030. I'm just giving you a timeline on what to expect.
That's when we will first see a monthly payment, 2030.
Yes, ma'am.
Joey?
So again, it would be nice if, Mike or Diego was here. But that's one of the things that, Mike brought up is and you brought up about the permitting. They're already there. If we're gonna start the whole RFP process again, it's gonna take another maybe 8 years. So they're almost there. They increased, or they agreed with the participation rent increase. So, again, that's why I believe that you guys, went ahead and,
Yeah.
accepted it, because to do the RP a year or two, approve it, then they're gonna have to get their own permits, their own survey,
Right.
their clearances.
They basically start from
Yeah.
scratch. Yeah.
So, again, that's, I
We're gonna
believe
lose-
that's why you
Yeah.
guys,
And then we'll have that permanent black eye with the oh, not permanent, but let's say that,
With the OPA.
yeah, with the OPA, then that's a loss.
But
Whereas this situation addresses that, and then the track history of you know, the entities involved and their reputation is what we have to give, you know, some kind of a credit to, and then that's what made us make that
Yeah,
decision.
I'm just gonna say, granted, Donkey is private, but that happened,
What
you know,
private? Well, I'm sorry?
Donkey, the
Donkey.
construction
Oh.
of, the construction of Donkey.
Yeah,
Granted, it's private, but they still had to get a permit. And they still had to do all these things. And I'm sure that planning happened way before 2013, after 2013, I'm sorry. So just, you know, this is, we've been discussing this, we've been giving consideration since I've been on the board, and I've been on the board for a pretty long time.
I'd like to add
We're
that-
just making no
I'd
progress.
like to add that Northern Market did start making payments for several months. Okay,
Yeah,
and then we had-
they made it, can they just?
then we had another economic, you know, situation, worldwide situation, then they came in and asked for and there was other factors involved, you know, there was workers and shortage of the workers. They had this situation with the buildup and the H2 and all that. And so the board went ahead and granted their
Again,
request.
again, my point is, Donkey was built, and they had the same worker situation, they had the same pandemic. Yet,
I don't think it's exactly the same thing.
they
Yeah,
had, I'm not saying it's the same.
yeah, it's
thing,
not. I think there's different
Well,
factors
they-
involved, yeah.
But I'm also saying, we started this in 2013.
2013.
It-
Today's 26.
That's just what happened. And we had that economic situation back then too.
It's been 13 years.
In my opinion, just for me, we approve this.
We did.
Give it the 6 months. Give it the 6 months. We're dealing with some heavy hitters, and if there's issues with it that they're experiencing, if they've experienced, you know, we have every reason to believe we had Gita confirm it. Gita advised us. We had the director, who was adept at a lot of these things, the board members. I believe also Ms. Westling was involved in that work sessions. That work session that was dealing with,
She and I were not on board at the time.
no.
So Jeff was also a part of
Ye-
the negotiation.
yes,
So
yes.
He became on board before,
Jeff
after
was-
you guys, yeah, so you guys were, you guys were a part of it, a part of the
Yes.
decision. You guys were a part of it, and Jeff was part of the negotiation team. So,
I was for COVID, yeah. I was a part of COVID, but I was not on the board when you did the second amendment.
My advice is we see this through. We got heavy hitters, they have a reputation. What happened with GEPA, with those new guidelines is what stalled it. And they had to bring in Duenas and Associates to solve that. So I urge the board to approve this.
Commissioner Cruz? Anything to contribute?
Just really confusing. You know, we are obligated to the beneficiaries of the Land Trust Bank. And again, I'm not ready to make a motion of vote. I just maybe need to continue to table this and have a work session if
It doesn't really make sense. We're
Yeah, I
discussing
just-
it right now. It doesn't make any sense not to do it. It doesn't make any sense not to do it. We're gonna start from scratch. You're gonna have another 8 years of, doesn't make sense not to approve it. We're already this far and they have a legitimate reason with GEPA. Otherwise, it would have been going on. And that they came to us with legitimate requests.
I am not going to withdraw my request to put a 50,000 conditional into that proposed draft, the third amendment.
Okay, you're withdrawing your request?
Yes, I'm not saying we're not going to approve it. We're not going to approve the extension or deferral. I'm asking again, and I've asked before on the extension, I've always had to put a down payment, which will eventually be applied towards rent credit and arrears. If not, they're not going to lose out on this.
We went through this before. on the
But
last
that
meeting.
is my condition among, to put a down payment on that of 50,000.
Chairman, if I may,
Okay, yeah.
I mean,
Pablo?
clearly there's some internal conflict among the commissioners. It's, for you all to discuss maybe, separately and not during this meeting. But I mean, just to reiterate, in the, the prior requests that we made in since January, I think the only issue before the commission, which is directly a result of the Second Amendment, which, as you said, was negotiated last year and reviewed, went through working session, was executed, which we're currently bound by. And of course, I'll defer to AG Miller on the advice to give to the commission. But under the Second Amendment that was executed, all we're asking for is to extend the timeline to secure the permit, which is clearly permitted under that Second Amendment, which does not have any additional conditions such as an extension fee or this renegotiation of the lease. I mean, I understand that there are some commissioners that are unhappy with the terms of the Second Amendment, but as you said, I think the only decision right now is whether the commission is going to proceed with complying or following the terms of the Second Amendment, which clearly says that if Northern Market encounters an unexpected delay caused by a government agency in securing the permit, that we may request an amendment to extend that specific timeline, and that the commission of the consent would not be unreasonably withheld. So AG Miller can confirm whether we provided the requisite notice, and then now we're reviewing the amendment. But I mean, everything else, I feel like that needs to be a discussion, among the commissioners if we're not ready to decide this today. But as far as kind of renegotiating the lease, I think what we did with the Second Amendment, by agreeing to, resume base rent payments after the construction deferment period, and then also to pay the greater of $45,000 or 50% of our NOI, which would be applied to the accrued base rent. And then thereafter, as Attorney Miller said, be, booked as additional income to the commission. That's all been discussed. So if those, unfortunately, if those numbers are not satisfactory to the commission now, we do have the Second Amendment, which was agreed upon and executed by the parties. So to the extent that the Third Amendment, if the commission wants the Third Amendment number one, if the commission decides that they still want to proceed and have a Third Amendment and have all these additional terms, it's something that needs to be discussed separately, and which I believe should be a meeting among the commission first before addressing Northern Market. But our only real issue now is the extension of the permit date, which is contemplated under the Second Amendment.
So basically, we have a negotiated agreement with both parties on the Second Amendment. And with the stipulations in there, they can come back for what she was saying regarding the permitting. they had this issue with the permitting that's beyond their control. They came up and asked us. And it's within the agreement. So we're still on the second amendment agreement that we agreed to. So it's not unreasonable that they come up with this situation with GEPA, which was beyond their control. So that's why they're asking for the extension. So it's within that Second Amendment agreement.
Mr. Chairman.
Vice Chair?
You know, despite all of this circumstances I've gone through the years, you know, we just have to move forward. That's my, we lose out. We're losing out anyways, but we need to move on. So let's go for it. That's all
Again,
I
it's
can
with-
say.
Again, we're just following the terms of the Second Amendment that we all agreed upon, signed. The stipulations are there allows them.
That's correct.
And it's not unreasonable, it's reasonable
Then why are we here?
to approve.
Let's
that.
let's
the one
approve it.
that's on- The one
Then
that's not, it's not unreasonable that GEPA placed new restrictions on, new conditions on their permitting process, which extended the time. That's not unreasonable. It took it beyond what we agreed upon. And it says there in the Second Amendment that it shall not be unreasonably withheld. Why would the company, the entity, Northern Market, be responsible for the timeline extended by GEPA? Why would
And
they-
all the other agencies.
or all the other agencies, why would they be at fault for that?
I have no further comment.
Because we don't have it, and we're not going today, because today we're not going to have a complete document with every blank filled in. If you simply wish to, we now have the report we asked for at the last meeting. I don't think anybody has any objection to that particular 3-month, 1 month timeline. But as Ms. Calvo indicated, she hasn't really focused on the text of the Third Amendment. I don't know that necessarily every one of the commissioners is focused on a text. So if we want to just adjourn this meeting and Ms. Calvo and I can get to what they're comfortable with as a final text. And then, because ultimately it's going to require the commission to vote to approve a document. We can just adjourn now and as fast as we can turn around the text of the Third Amendment, we'll bring it back in front of the commission.
Okay, and Director, I'd like to get a copy of the Second Amendment,
Yes.
unless everybody already has it, but give it, please,
Disseminate
disseminate out to it.
That's the issue.
No, there's a misunderstanding of the Second Amendment, because otherwise, to me, if there was a total understanding of the Second Amendment, we have an agreement.
I don't think
But, Director, please disseminate the Second Amendment. So we'll just go ahead, unless you have any other.
No, I agree, it's not final, so tie up the loose ends and come back.
Okay, but
For the third,
Commissioner Cruz?
right?
Yes,
Chair?
Attorney Miller, please involve Data, our property manager, on your negotiation with Ms. Calvo. Thank you.
Okay. Let's do that.
Then we'll need a motion to adjourn.
Okay, any final things you wanna add, Ms. Calvo?
No, basically, I think it's just, I need to just call the question, I guess, is whether, under the Second Amendment, if you, and AG Miller can confirm, but the way that it's written was that, and this was language that we negotiated with GALC, was that if the permit wasn't secured by a certain date, then that triggers a lease termination date. So, at this point, we're just waiting for that decision. I know that Commissioner Wesley had asked at the last meeting why we didn't, immediately proceed with the DCA work. But of course, without a valid lease agreement and knowing that there's a termination right that's there, of course, we're going to proceed, with caution before investing any additional funds in that work. So, I mean, it's really a simple issue. And as I mentioned, something contemplated, something that under the lease agreement, the commission is supposed to agree to the extension if the notice was provided and if it's before for a government delay. And that consent should not be unreasonably withheld. That's the only real issue before us now. It's just that additional time. But if there's other conditions that the commission wants to discuss, then I can discuss that with Attorney Miller.
Okay. Thank you, Ms. Calvo.
Thank you.
Okay, with no further questions, motion to adjourn.
So moved.
Okay. It is 3:33 p.m. This meeting is adjourned.
Thank you.